a little while.
Yeah, did we do a video in July?
I think so. But things have been moving along. We were going to talk today about something that I think there's a lot of questions about that we get, maybe a lot of confusion, things like that, and that's how an estate is open. So when somebody comes in and they say, my relative or whoever it is passed away, here's a copy of their will, they've nominated me as the executor, what do we need to do?
First, you got to file the will with the courthouse in the county where that person resided. So if mom or dad or grandma or grandpa passes away and they're a resident in Logan County, we take that will, what we believe to be their valid last will and testament, and we deposit it with the county that that person resided in. So if somebody dies in Lincoln, we take that will over to the Logan County Courthouse and we deposit it there.
And that's it. That's all that we need to do to get that executor ability to do what they need to do?
Not quite it. So just because you're named as an executor in a document, it has no bearing on how you can act until you get a court order that says you are appointed the executor, and then you get what I call the golden ticket. You get the letters of office, and then those letters of office are certified by the circuit clerk, and then you take those to any institution that you need to use to gather the decedent's assets. You use those letters of office to contact possible creditors. It essentially gives you the authority to manage and then eventually distribute the person's estate.
It's kind of the same deal if the person that passed away did not have a will. Somebody still has to be appointed by the court as the administrator of the estate. And the way that we do that is file a petition with the court and ask that that individual, whether it be an administrator or an executor, be appointed by the court. We have to outline for the court certain information about the heirs and beneficiaries of the deceased. We have to file some other documents in order for that to happen, but it's not an automatic process. And I think that may be one of the biggest item of confusion that I see, I think.
Yeah, I think it's a common misconception that when somebody reads a document and they see, oh, I'm appointed as the executor, I can go out and I can act as executor. And that's not quite true. You need that court order, you need the letters of office. So whenever we open an estate also, we get what's called a tax ID number. So just like Glenn and I have social security numbers, we file our tax return with our social security number. With the IRS, these different entities, whether it's an LLC, it's a trust, if we open up an estate, they will get their own unique tax ID number. And you take those letters of office and you take that tax ID number, and the first step is to open up a bank account in the estate's name. So after you get that bank account opened, you get appointed as the executor through the court system. You open up the bank account, and then as you gather the assets, you're now transferring them over from that individual's name into the name of the estate, and then their tax ID number will control them going forward.
Yeah, and I think that's a little bit different than like in a power of attorney document. If I nominate an agent in my power of attorney document, that person has the authority vested in them by that document automatically. They can take that document and use it. That's not necessarily the case with an appointment in a will. What if I'm appointed as executor in a will and I don't want to do it? Do I have to?
You do not have to. You can refuse, you can resign. I guess you would have to be appointed before you would resign, but most of the documents that we draft say that XYZ people are nominated as executors so long as they are willing and able to act. And the first step is make sure that they are willing. So if somebody's not willing to act, then you go through the succession of the executors within that document. And if person number one does not want to act, maybe person number two does, then they file a petition and they state that person one was named as executor, they've refused to act, and then I am named as the backup executor, and I am willing and able to act. Can anybody act as an executor?
Anybody that is, testing the memory here, an adult, so over 18,
Yep.
citizen of the United States, and not a judge disabled by any court, and not ever been convicted of a felony, then you're qualified. qualified.
Is there any way around that last requirement? If somebody's been convicted of a felony, is there any way to undo that or to get them appointed as an executor?
Not in an estate.
So in Illinois, it's pretty clear that if somebody has been convicted of a felony, they're not qualified to act. So when we say in our documents somebody is willing and able to act, with the willingness part, if they are willing, that's great, but if they are able to act under the laws of the Illinois, they are not able to if they do have that felony conviction. So that's something that doesn't come up too frequently, but we have seen it happen in the past. In that situation, you just go down the order of who is named as the successor. And so what happens if nobody's named as the successor at that point?
Then the great state of Illinois tells us what who's next in line. So there's a section in the statute that says particular people have preference. So it'd be spouse, child, relative, and it kind of goes down the line as to who would be able to act or nominate somebody to act. So without that designation in a will, we get to rely on this wonderful state that we live in.
And that
who I'm sure has our best interest in mind.
And you can that person is then just able to act automatically, right?
Nope. They would have to go through the same process. They've got to petition the court to be appointed, or they have to petition the court to appoint somebody else to act. And then if there is no will, that person, whoever it is that's going to act, would need to post a bond and do some of those things. And that's probably a little bit deeper than we want to get into this video.
Yeah. So with the power of attorneys, like you mentioned, when those documents are executed and an individual names someone as their agent, that becomes effective upon the signing, as long as the document says it's effective immediately.
Right.
No court approval necessary on a power of attorney document.
Not on those. We always make sure that people that are signing them are competent, so they know what they're doing. They understand, who their children are, the items of their bounty, things like that. But once those are executed, typically those are effective immediately, and those can be used right away. And those power of attorney documents, whether it be power of attorney of property or healthcare, are going to be revoked automatically at death. That's when we're going to look to a will or to the statutes to see who's up next to help out.
So if you're acting as agent for dad and dad passes away, you can't use that power of attorney after dad passes away?
Nope, that's revoked automatically on death.
And then with the guardianship, there's certain situations you can have a guardianship of a minor child, or you can ask for a guardianship of an alleged disabled adult. Those typically need court approval too. I think there's one exception. The state of Illinois does allow for what's called a short-term guardianship, and I think we've discussed those in past videos. But that's a document that appoints certain individuals as guardians of minor children, and that document's only in effect for a temporary period, a short-term period, and the state of Illinois says that's not to exceed 365 days. So I know it's common practice. When you go on vacation, you typically execute a short-term guardianship.
We typically do. We typically nominate somebody to act as guardian in case somebody needed to deal with our children's medical needs or something while we're gone. That would ease that burden a little bit. But if somebody's disabled or there's minors that don't have living parents, that's pretty much the only way is to get a guardianship of them, and the guardian then has the ability to do those things that an agent under a power of attorney would have. But hopefully if you're getting your powers of attorney done, you are going to avoid having to get a guardianship if you were to become disabled or something along those lines.
What about revoking a power of attorney? What type of mental capacity do you have to revoke a power of attorney?
None. You can revoke it anytime.
You can rip that document up whenever?
Rip that baby up, do whatever you want. That's one of the, in my opinion, fatal flaws with it. Unfortunately, we see people execute those and somebody nominated as the agent, and then that agent does something to anger the person who's unfortunately become disabled, and that person has enough capacity to say, you're out, you're revoked, I'm not going to let you do this anymore to me, I'm going home, or whatever the case may be. And those are sad situations, but unfortunately that's the way the law reads.
And if that person is a disabled adult and they've revoked their power of attorney, I guess how do you get somebody to take care of their affairs at that point?
Guardianship.
Back to the
somebody
guardianship.
would have to petition for guardianship, and it's an unfortunate reality, but there's an avenue for that there.
So moral of the story is get your estate planning documents in order so we don't have to go through the court system and get that court approval while you're still living. After your death, if you have a last will and testament nominating an executor, make sure that your executor knows that they don't get to automatically act. They do have to get that court approval, and they do have to have those letters of office to act on behalf of that person that died.
I agree. We've gotten a little sports in the last month, a little bit.
Yeah, looks like the NBA bubble theory is working as well as it can. Those darn Cardinals are kind of weighing down the MLB.
Ruining baseball even when they're not playing.
I heard something the other day that at the end of the year, if not every team can get all of the 60 games in, they're going to determine playoff standings on your win percentage.
I guess, in theory, if you play less games, your win percentage could be a lot better if you win a couple of them.
You think if the Cubs said we all got COVID for the rest of the year, they could end the year with an 800 win percentage?
Yeah, it'd be a pretty good win percentage.
I think that might be a strategy at the end of the season if a team is on the brink there and they don't want to face, that last week at teams. Maybe they say, well, we've got a COVID outbreak and we're just going to keep our win percentage at this real high number right now and take any chance out of us not making the playoffs.
You could text Mr. Ross and let him know about that. Maybe he'll take that under advisement. All right, guys. Well, thanks for joining us. We will see you next time.
Take care.